Hi there. If you're watching this video, then you might be headed to mediation in the near future. In this video, I'll be explaining the difference between shuttle mediation and non-shuttle mediation, and I'll also be providing an overview of the mediation process generally. Picking the right mediation process for your particular case can have a significant impact on the outcome, and so it's really important that you understand the difference between shuttle mediation and non-shuttle mediation so you can make an informed decision. So in a nutshell, shuttle mediation involves the mediation process where the parties have no direct contact with one another. Prior to the actual mediation occurring, the mediator will have a private intake session with each person separately. During the intake session, the mediator will ask a range of questions to better understand the issues and the background to the relationship issues from each person's perspective, and this is in a private setting. During intake, the mediator will perform a risk assessment. So if there is a history of family violence or there are power dynamic issues within the relationship, the mediator might suggest that shuttle mediation is more appropriate, but it's also open to either party to elect the shuttle process if they believe that that would result in a better outcome or make them feel more safe and comfortable on the day. So common situations where shuttle mediation is preferred is where there is a history of family or domestic violence between the parties, or where those power imbalances and the power dynamic issues exist between the parties, which might impact either party's ability to freely and openly negotiate on the day. Since COVID, I've noticed that a lot of mediations are actually taking place electronically rather than face-to-face, and we definitely offer this service. So we often conduct mediations by way of Zoom, and some people prefer not going to the actual same venue as their ex-partner or the person with whom they're having the conflict. So we offer both services. We can do mediation Australia-wide online, and we also offer face-to-face mediations at physical venues across the east coast of New South Wales. Whether you'd prefer face-to-face or electronic mediation is something that you can discuss with me or your mediator during your intake session. Okay, let's talk about the mediation process generally. So on the actual day, so when you show up to mediation after your intake session, the mediator usually begins the process by giving their opening statement where they introduce themselves and they talk about important concepts like the fact that mediation is confidential. Anything that is said or done at mediation must be kept confidential unless a limited exception applies, and you will be made familiar with the limited exceptions during the intake process. The mediator will also explain that the things that are said or done at mediation are inadmissible in court, which means that you can't later use anything that is said or done or any verbal offers against the other person in future court proceedings. The reason mediation is confidential and the things that are said or done are inadmissible in court is so that both parties feel free to openly negotiate and put options forward without the fear that what they say or do will be used against them later in court proceedings. There is one very important exception to confidentiality and inadmissibility, and that is both parties or all participants prepare a written agreement and they sign and date the written agreement, then the content of that written agreement is no longer required to be kept confidential and it is admissible in court, which means that either party can rely on that agreement or that document in future court proceedings. This is why whether all parties sign and date an agreement is a really important decision, and we suggest that you seek legal advice prior to signing or dating an agreement because it can have an impact on future court proceedings. The mediator's role is not to provide you or the other party with advice or to make decisions for either of you. The mediator's role is to facilitate the process and to assist both of you to negotiate and reach agreements in relation to the issues that have brought you to mediation. Mediation is essentially a structured negotiation process, and the mediator's role is to facilitate that structured negotiation process. After the mediator's opening statement, it's then the parties' turn to give their opening statements, where they summarise the issues that they'd like to discuss and resolve at mediation. Now, you can attend mediation with or without lawyers. We offer lawyer-assisted mediation services, but we also offer facilitative mediation where there's no lawyers involved. If you have your lawyer can give your opening statement for you if you'd prefer that. So with non-shuttle mediation, the parties begin the process with the mediator all in the same room. So there is that direct contact throughout the day and throughout the mediation process. Whereas with shuttle mediation, it runs with the same process, but the parties don't have direct contact with one another. The mediator shuttles from room to facilitate the mediation process. From each party's opening statement, the mediator will prepare an agenda, and the agenda will set out the topics and the issues that each party would like to discuss and resolve at mediation. The agenda will guide the discussions throughout the day. After the agenda has been set, we'll move to explore and discuss the issues in dispute so we can better understand one another's perspectives in relation to those issues. After the exploration phase, we'll move to discuss some proposals and some solutions that might resolve the issues that are in dispute. At any time during the mediation process, either party can indicate that they'd like a private session with the mediator. Anything that is said and done during those private sessions between the party and the mediator will be kept confidential and won't be disclosed to the other party without consent. The mediator might also call for private sessions at their will throughout the day, and this is very common. Now, importantly, you can swap from non-shuttle to shuttle mediation where you have no further contact with the other party throughout the mediation process if you'd prefer that. And also, say you start with shuttle mediation, but things are running smoothly, you can also then opt for a joint session if both parties consent throughout the day. So it's not like if you pick shuttle versus non-shuttle that you must stick with that. It depends. Things can change on the day depending on how everyone's feeling and how things are running on the day. So the mediator will have private sessions, and after the private sessions, we'll continue to negotiate and we'll try to document and reach points of agreement in relation to the issues that have brought both of you to mediation. The mediator will set out any points of agreement in a document. Now, the particular document will depend on what type of mediation you're attending. So at the end of the mediation, hopefully you've got a document which sets out points of agreement, and then it's the important decision for you to make as to whether you both sign and date the agreement. Mediation is not like a court hearing where there is cross-examination and we will not be scrolling through all of the evidence and scrutinising either party's evidence. There will be no finding of fault on behalf of either party. It's a solution-focused, structured negotiation process. There are significant benefits to resolving your matter at mediation rather than proceeding to court. Mediation provides you with the option to resolve your matter on the day. So it can often take years to reach a final hearing in court matters. Mediation often costs a fraction of the cost of going to court. So you can spend your money on you or your family rather than paying court fees and legal fees. And also at mediation, you and the other participant or other party retain control of the outcome. If you go to court, it is undoubtedly unpredictable. You don't know how the evidence will fall after cross-examination. At mediation, you decide the outcome rather than a third party who hasn't actually met your children, if you're doing a family law parenting matter, and who doesn't really know you or the other participants, and they only get a glimpse of who you are as a person. So at mediation, you remain in control of the outcome, and that's very empowering, and it can assist to preserve positive relationships. My name's Catherine, and I'm a lawyer, and I'm also a mediator practicing in Australia. My contact information is down below in the description box, as is a brief overview of what we've discussed in this video. If you've got questions regarding the mediation process or shuttle versus non-shuttle mediation, let me know in the comment section down below.